Hi, everyone. My name is Heather Heft. I'm a partner at Schumann, Updike, Kaufman, and Gerber, a women-owned general practice boutique in New York and New Jersey. Today, I'm presenting the hot topic for November, probably because I really miss speaking at the IPPAC meetings. Today's topic is What's the Matter with You, Facebook and a Global Rebrand. I would like to note that I am not Facebook's attorney, so a lot of what I'm going to speak about today is from publicly available sources combined with trademark prosecution strategies, which may or may not have been considered by Facebook. So I'm going to start with a joke. Not a great joke, but a joke nevertheless. I told my son that Facebook was changing its name to Meta. He asks, "What's a Meta?" And I said, "Nothing. What's the matter with you?" Anyway, so you want to change your company name and rebrand. There are a lot of reasons for a company to do so. A company may rebrand to highlight to a new focus, like Datsun becoming Nissan in the 80s, or a company may rebrand to escape controversies, like think Andersen Consulting to Accenture after the Enron scandal in 2001, or Philip Morris to Altria to make us all forget about the harm of smoking. Or maybe there's a conflict with a third party, like the WWF to the WWE, so we would no longer confuse wrestlers and pandas. Facebook chose a real word as its new brand. Meta means referring to itself or the conventions of the genre. For the definition, I would like to thank Google, itself a subsidiary of Alphabet, after a 2015 rebrand and restructuring. I'm not going to say why I think Facebook changed its name, but I can say that speculation about the name change was rampant. Before the announcement, the web address meta.com redirected to meta.org, the home of a biomedical research discovery tool developed under the stewardship of the Chan Zuckerberg Initiative. Currently, meta.org houses the tool, and meta.com redirects to a website about the rebrand. In addition, in April 2021, the initiative acquired a trademark registration, for those who are curious, registration 5548121, from a Canadian company, Meta Inc., which covers services in classes 35 and 42, usually associated with business and computer-related services. In addition, over the summer, Mark Zuckerberg himself said that over the next few years, quote, "we will effectively transition from people seeing us primarily being a social media company to being a metaverse company." In fact, he mentioned the metaverse at least 16 times during the company's July 2021 earnings call. I saw a Bloomberg article which stated, quote, "any company named Meta would also be able to lay claim to the term metaverse as its own rather than the generic descriptor it currently is." Wow, all of that is setting my trademark spidey sense in motion. The press and the head of the company pretty much admitting that their mark is descriptive. Do we think that the way that Mark Zuckerberg himself has used the term metaverse, that the US Trademark Office is now going to find his mark Meta, in fact, too descriptive to be registered as a source identifier? Well, we don't know how or if Facebook cleared the mark for use and registration. If I was advising a company in a global rebrand, I would start with a preliminary trademark search, moving to US full searches and searches in those jurisdictions where you do most of your business, or even searches worldwide, depending on your business reach, market share, budget, and timing. We do know that Facebook filed a broad US trademark application for Meta and Design on October 28th, 2021, the date of the announcement, in the name of Facebook Inc. Often, with a new product launch and rebrand, we like to have our marks filed before the announcement. With the United States intent to use system, we can file marks before launch and hopefully iron out any prosecution difficulties before then. Also, a company often likes to have backup marks if we're pushing a global brand. There are a lot of countries out there, and it is unusual that one name would fit all as well as be available to all. In fact, speaking about one name fitting all, one issue we usually address in a global brand is translations. The downside of a global brand stemming from the US is, well, most of us speak only English. it has come to light that Meta actually means she is dead in Hebrew. As you can imagine, Twitter is having a field day, including folks that believe that Mark Zuckerberg, himself a Reformed Jew, knew that the mark meant dead and chose it on purpose to indicate that he and Facebook will be leading all of us to our untimely social media related ends. So what do you do if you want to keep your brand quiet before launch and you don't want folks to know about you? Well, I guess you can file in the name of a different company. Note that in the United States, under our intent to use system, an intent to use trademark application cannot be assigned except to a successor to the business of the applicant to which the mark pertains, if that business is ongoing and existing. Even assignments between related companies need to meet the strict language of that statute. One way to avoid this is to have the trademark applicant license the rights to the applied for mark to the related entity so that the eventual use of the mark by the licensee can form the basis for filing the proof of use. So that's a way to deal with this if you want to have related entities and sort of set up a stealth subsidiary so no one would know that it really was Facebook. But what if that was even too public? Well, you can file a number of marks to throw off the scent. When the New Orleans Hornets renamed itself the Pelicans, the team filed marks such as the Mosquitoes and the Swamp Dogs to throw the press off track. This could end up costing a lot, especially if you take this strategy worldwide. Here, Facebook could have used the priority system to file several applications in the US, and within the 6-month priority period, taken Meta global. Facebook could have used the Madrid system to use the US application as a home base to extend an international registration abroad. While we're on the topic, I'm going to talk a little bit about the Madrid system here. There are downsides inherent in using a US intent to use application as the basis of a Madrid filing in this situation. The applicant is limited to more subscribed goods and services descriptions that we use in the US. In addition, there's a 5-year codependency period of Madrid filings. So that means that the US rights would have to live for at least 5 years. So Facebook would actually have to use the mark Meta on all of the goods and services that it applied for in order for those goods and services to stay alive in the Madrid extensions. I tried to create a document, a PowerPoint document with all of the goods and services that Facebook filed for. It crashed my PowerPoint document, which is why I do not have a PowerPoint document. It's a lot for them to prove. So filing Madrid and using the US-based description may not be the best case scenario for Facebook in this situation if they're trying to obtain broad rights abroad. Well, what about a stealth filing? In most countries around the world, trademark applications are a public record once they're filed. We all know that we can go into the US Trademark Office and see what's been filed and what it was filed for. However, some countries do not publish applications in a searchable online database. For example, to search in Jamaica, you must physically go to the Jamaican Trademark Office. Thus, some companies like Tesla and Apple have been using foreign priority rights to keep their trademark application secret. They use 44D, allowing applicants to claim priority to a prior filed foreign application. Companies first file in a country like Jamaica, then can gain 6 months of secrecy before they have to file their US application and claim their 44D right of priority. As US companies, they cannot rely upon this foreign right as a registration basis, but they can still use the intent to use system to prove use of the mark in commerce in due course. I also note that Facebook filed its application with its infinity logo and in color. One reason to file a mark with a design is to attempt to differentiate the mark from others on the register. In light of the 651 other active trademark applications and registrations, which include the word Meta, this is as of a few days ago, I'm sure there's more now, there's a good chance that this was Facebook's filing strategy. In order to gain the most protection, however, it's usually best to file the word and design elements separately, so each element is protected separately. However, if you believe that either your logo or your word mark may face challenges by the trademark office or third parties, it is often a good strategy to file the word and logo together. That may be what the Facebook attorneys were going for here. Well, what about consents? In the US, consent agreements to register between two parties are almost always accepted by the trademark office, so long as they conform to the current practice. However, many trademark offices abroad do not accept consent agreements. Some countries, like Japan, use the practice of an assignment back, where you assign your application to the blocking registrant, and they assign it back to you after registration, usually for a cost. And the law on consents is often a moving target. I just received word this week that the Chinese Trademark Office is no longer looking at consents favorably. Consent agreements were often an onerous process in China anyway, because it's really a US-focused solution, but it was something that we could rely on if we really, really needed to. But since Facebook is actually banned in China, at least they don't have to deal with the Chinese trademark registration process, which is onerous and complicated at best. Do we think that Facebook is going to be able to register this mark worldwide? I say probably not. Too many prior third parties, too many descriptiveness refusals. Is that all right? Well, in a nutshell, maybe. When you adopt an arguably descriptive mark, it's okay in some jurisdictions to use the mark without registration. This is especially true in the US, which we are a first to use jurisdiction. We believe that everyone is entitled to their little niche of use so long as there is not a likelihood of confusion between your mark and other marks. Other jurisdictions, well, they're a first to register rather than a first to use, so registration holds more weight. In addition, countries without use requirements, many registrants have broad trademark registration rights, broader than they would have in the United States. This could cause both prosecution delays for meta application, as well as potential opposition by these third parties. I hope Facebook has a trademark war chest ready to fight off any opponents. In fact, an Arizona company already said that it would sell its rights in Meta to Facebook for $20 million out of the Meta trademark application on August 23rd. It is likely that Facebook will face additional opposition proceedings once its trademark application has been published in the US. One way to deal with this, of course, is to settle. A coexistence agreement, perhaps, where everyone agrees to stay in its own lane. But sometimes there are risks in settling, especially if there's a financial payout. Others may seek the same deal that the prior company got. A company often faces a fine balance. Do you fight or do you pay off the opponents? There are financial costs and risks either way. Many rebrands fail. Do we remember how Netflix moved to Quickster in order to separate their DVD business from their streaming business? Neither do I. Pizza Hut to the Hut, so they could serve more than pizza? I, for one, do not find it attractive to be eating in a hut. And really, who calls Google Alphabet? Will it matter if Facebook's trademark strategy for Meta works? Probably not. I, myself, cannot ever imagine calling the company Meta. I bet most of us will not. This made for some great headlines, a minute away from the evils of social media, and a fun trademark discussion. But to me, it will forever be Facebook, the way I can keep track of my high school classmates without ever attending a reunion, and knowing everyone's birthday without ever keeping a calendar. So if anyone has any questions, feel free to direct message me on Facebook. But really, if you have any questions or you want to discuss any other elements of trademark prosecution, this is the time to do so. And I thank you very much for your time.